Hello everyone, welcome to my classes. This is Priyanka from CS Priyanka's Professional Classes. This is part 2 of forms of business organization. Here I have included all the formation procedures of all the forms of business organization. So let's start. Procedure for formation of different types of business organization. First is sole proprietorship. How you are going to form a sole proprietorship? First is it is formed, managed and controlled by one individual, obviously. That's why its name as sole. No deed or agreement is required for this formation, but registration may be required under the following enactment as prevailing in the respective states or of the CG, central government. So there are some different act is there. Those act can, whenever you are going to open any sole proprietorship business, so there are separate acts are there which are which may come implement means which may come applicable on your object or business. Okay, so what are the things may come? The following enactment may there in case of respective states. It depends on the different states as or the CG or as per the requirement of central government. So what are those acts? Shops and Commercial Establishment Act. It is a state specific. So say state specific means it depends on which state you belongs to. On the basis of that, this act is going to be implemented. This act will become applicable. So next is law relating to the professional tax, or if you want to register your sole proprietorship business under Micro, Small or Medium Enterprises Development Act 2006. Or you can register as a small scale industry, that is also state specific. You have to check whether your state requires to follow such act or not. GST registration is mandatory nowadays, so you have to register, you have to obtain the GST registration number, as well as intellectual property laws is going to be applicable on you whenever you are going to start a sole proprietorship business. So these are the steps and procedure for sole proprietorship business. Next, come to partnership. Partnership formation or registration is totally governed by Indian Partnership Act 1932. That means how you're going to register your partnership firm. This act is going to regulate you. That is Indian Partnership Act 1932. But one thing, registration is not mandatory. But also if you don't register, also no penalties is going to be imposed, or no penalties are there for non-registration. Only the thing is, unregistered firm cannot file a suit against said firm or his or her partners to enforce any right arising from the contract. That means if your firm is unregistered and if you have not registered your firm, that means you cannot enjoy any type of legal benefits. Next is registration procedure for partnership firm. So in case if you want to register your partnership firm, what are the procedure you have to follow? First is you have to file an application with registrar of firm situated in the area where your business is located. So you have to check in the area where your principal business or office, your head office situates. There in that area you have to file an application with ROF, that is registrar of firm. Now along with this application, some of the details you have to include. Those things like your name of the firm, as well as the name of the place where your business is carried on, or any other place where you want to do your business or you want to carry on your business. Date, on which date your partners of the firm joined. So the date of the partners joining the firm. The partner's full name as well as permanent address. And also you have to include the duration of the firm. That means for how many years, for how many years you have, what are the duration or the specific term you want to continue your firm. And lastly, their application needs to be signed by all the partners of the firm. So whoever partners are there, all the partners needs to sign such application. Next is, every partner, whenever they are signing the application, they needs to verify. First they have to review the full application, then they needs to sign. So afterwards, if any case happens, like they cannot blame other partners that we have signed without reviewing the full application. So in the act, it is written that every partners, whenever they are going to sign the application, they needs to verify the same. After that, you have to file an application in Form 1 and duly file. You have to file affidavit and certified copy of partnership. You have to submit one affidavit also, one partnership certified copy of partnership deed, that is in the stamp paper, and the place where you are once means you are registering your registered office owner, means proof of ownership you have to submit, whether it is the office you have taken, it's your own office, that means you are the owner of your office, or else you have taken on rent, lease agreement is there for such room. So whatever is there, proof of ownership of the place of business, of the rental or lease agreement thereof, you have to submit. And registration under Income Tax Act is also, means Income Tax Department is also mandatory and should have a PAN card in the name of your firm. So you have to obtain PAN card in the name of PAN number in the favor of your firm, as well as you have to open one separate current account in the name of the partnership firm, from where you are going to do all the transaction relating to the business activities. Next, come to HUF, which means Hindu Undivided Family. See, a HUF deed is a written formal document on a stamp paper. So this is simply on a stamp paper. They will write every details, and we call them as a HUF deed. So if you're talking about a formal paper, that paper should be in a stamp paper. That means the paper should be the stamp paper where all the particulars will be mentioned. And the eldest member, male member of HUF, whoever will be the eldest member of the family, that person will become Karta. Name of the members of HUF and name of the HUF is also required to be stated in HUF deed. So in the deed, you have to mention all the name of the members of HUF, as well as the name of the Karta. And also the HUF name also you need to mention. Example, the HUF name will be like this. Whoever will be the Karta, for example, I have given like Hari Kumar is a Karta. So your HUF name will be Hari Kumar HUF, like this. So whoever will be the Karta, along with that name, HUF will be affixed. HUF deed also states the capital and sources of capital with which HUF has been initiated. So how you have started your HUF, that sources of capital as well as the total capital structure is also going to be mentioned there in the HUF deed. Each member of the family needs to be given, means needs to submit the declaration which stated the following. So whoever will be the member of HUF, the declaration needs to be obtained from each member of the family, and it should include the following, like Karta has the authority of accounts vest in his hand. So full accounts responsibility will be vested on Karta. No one is going to take care relating to the accounts, and Karta is not answerable also to anyone relating to the money or accounts. Karta holds the right to govern all the transaction of the HUF accounts on behalf of the members. A rubber stamp of HUF will also be prepared. It should be rectangular and need to be affixed on all the documents. So it should be in the rectangular form, and all the papers of the deed on every sheet that needs to be affixed. That is seal, rubber stamp of HUF. And it is recommended that deed should be notarized. It should be notarized by the public notary. Okay. And in this way, you can register the deed. And once you register the deed, you can obtain PAN, that you have to register yourself with the Income Tax Department. And after registration, you can open a separate bank account for the HUF, from which you can continue your transactions relating to the business activities. Next, come to LLP, Limited Liability or Partnership. To form LLP, the partners need to acquire DPIN, which is known as Designated Partners Identification Number. Whenever they're going to file the forms, and they will get this number, that is DPIN, Designated Partners Identification Number. So after acquiring this, they need to apply for getting DSC, that is Digital Signature Certificate. Though nowadays everything is digital in nature, so they also need to have DSC with them. So those designated partners should have DSC. So whenever they need to register DPIN and DSC with this website, that is llp.gov.in, whenever they will enter into their in this website, they need to register their number, that is whatever they received, that is DPIN as well as DSC. After that, they're going to check the name availability, whatever name they fixed for their LLP firm, whether it is available or not, whether it is matching with some other business or not, they have to check it. After that, they have to download the LLP forms. Those forms need to be filed electronically. They can track status from the website. After that, they are going to receive a certificate. And once they receive the certificate, LLP ready to function. So they can start functioning. So this is the procedure for LLP. Now come to AOP or BOI. Here registration actually is not compulsory, but execution of deed is also optional, but you can execute deed if you want or to enjoy the legal benefits. This is totally governed by Income Tax Act 1962, and there should be minimum 2 but no limit of maximum members. That is not a formal business organization. It is obviously not a separate legal entity because it is not a body corporate. Here liability is unlimited unless agreed otherwise in an agreement. If in agreement separately you mention that this member is having limited liability, that is okay. That is separate issue. Other than that, all the members are having unlimited liability. Here the main intention is income, not the business. So income, not business, is essential characteristics of association of person. So here income is one of the main characteristics of association of person, but not business. Income in association of person may come from like lottery, prize money, donation, because they are having no fixed plan for business. So their intention is only to earn income. So usually it may comes from lottery, by winning lottery, or any prize money or donation, all these things. So these are the details of AOP and BOI. Next, come to cooperative societies. You can do your business by opening cooperative societies. So if you opt for cooperative societies, a cooperative society is formed under the Cooperative Societies Act 1912 or under the relevant state cooperative societies law. A cooperative society can be formed by at least 10 adult members. So minimum 10 adult members should be there to form such society. Otherwise, you cannot form it. Members willing to form a society must have a common bond among them. So they should not agree, they should not disagree, okay, against something. So they all should have a common bond among them. Then only they can open this cooperative societies. Provisional committee will be there to select chief promoter of the society. Now you have to select a name for your society. What name you want to give for your society. After that, you have to file an application to the registration authority, society registration authority. You have to pay the entrance fee as well as share capital, all these things. After whenever you will pay or you have fixed the share capital, after that you have to open one separate bank account. Registration application you have to file with such authority. Once register is acknowledged by them, or once they grant your registration application, you are going to get the registration number. Once you receive the registration number, you are a registered cooperative societies. You can function, you can start functioning, and you can start your business. Next is statutory bodies and corporation. We already discussed in the previous video that what do you mean by statutory bodies or corporation. It's a type of corporate body which is managed and regulated by either parliament or state legislature. So it is a corporate body. Such corporation are managed by the board of directors which are constituted by government. So government is going to constitute board of directors. Now these board of directors are going to manage such corporation. Now, state provides help to such corporation by subscribing to the capital fully or wholly. It is fully owned by the state. So, wherever in which state you are going to start your statutory bodies, that state is going to subscribe to the full, means your capital fully or wholly. Now, statutory corporation is answerable either to parliament, legislature or state assembly, whoever creates it. So whoever is going to form it, the statutory bodies is answerable to that authority. Employees are not government servant, even though the government owns, manages a corporation. They are recruited, remunerated, and governed as per the rules laid out by the corporation. So whoever works under the corporation or statutory bodies, they cannot be treated as a government servant actually. But whatever means, they are going to be recruited or remunerated as per regulation laid down by the government. Corporation means laid down by the Corporation Act. Statutory corporation enjoys financial autonomy or independence. It is not subject to the budget, accounting, or audit controls. After getting the prior permission from the government, it can even borrow money within or outside the country. So actually, these statutory bodies cannot do anything without the approval of government, as well as that parliament or legislature government. And it is not subject to budget or accounting or audit control. So its financial status is totally autonomous in nature. So they usually get the government support, and also they have to take the permission for borrowing any type of money within or outside the country. Now come to joint venture. First step is planning. For joint venture, they have to plan. Now planning involves these includes all these. So like they have to determine their needs for joint venture, why they want to start joint venture business. Okay, so they have to define their business objectives. They have to research potential joint venture partners. So they cannot take they cannot choose partners like that. So the partner should be potential enough to run the business. So they have to take into the consideration the network with other companies also. They have to schedule follow-up meetings. They have to determine if the two companies are a good fit or not. So they have to adjust with each other now. So they have to determine whether okay, other parties are okay for me and it's a good fit for me. They have to prepare a non-disclosure agreement, and also they have to draft a letter of intent. What is their actual intention? They have to draft it. Next step, joint venture need to decide the format of their own joint venture. Like they have to review their scope of the overall undertaking. Now what they wants to do, they have to review the full thing. They can create a new corporation if the project is large. For example, two partners or two companies are forming a new company if their project is large. In case they can form partnership also if they wish to retain individual identities. But in joint venture, the main important thing is like their identities. They have to maintain their identities separately. After maintaining their identities, they can do their business. And they have to draft a contract for smaller and temporary project. Whatever they do, either it's a smaller or temporary, obviously if it's a smaller or temporary project, it's uncertain in nature. In such cases, it is mandatory to draft a contract for such smaller and temporary project. Next step is they have to enter into a joint venture agreement. They have to draft it, drafting the joint venture agreement, and these things they have to include there. They have to introduce the purpose of the joint venture and the parties. They have to define the relevant terms. Identify the business objectives of the joint venture. They have to define the structure of the joint venture. What is their structure? They have to define the management of the joint venture. They have to address financial issues related to the joint venture. They have to define the role of employees. What will be the role of employees whenever they will continue as a joint venture? Agree on procedure for resolving any controversial or disagreements. If any controversial topic is there will come in future, or any disagreements are there, so what will be the procedure to resolve all those problems? They have to decide the duration, or about they have to decide the duration as well as the termination procedure. That means for how many days they are going to continue such joint venture, and for termination such joint venture, what will be the procedure? And also they need to include the confidentiality clause. That means they have to maintain the secrets, otherwise what will be the penalty or punishment will be there. And after, at the end, the agreement should conclude should have the signatures, until and unless both the parties sign the agreement is not valid. So they have to conclude the agreement with signatures. Lastly, company. So company incorporation, I would request you can read from my other videos, which I am going to upload today only or tomorrow in my channel. But here I have discussed a little bit, like company means promotion is the first stage in the formation of a company. Like promotion of a company refers sum total of the activities of all those who participate in the building of enterprise up to the organization of the company and completion of the plan to exploit the idea. So you have to first stage is the promotion of a company. How you are going to form your company, that you have to promote. Next is you have to start your incorporation process or registration process. So how you're going to register your uh, company, that is the second stage. So third is, in order to get a company registered or incorporated, the following procedure needs to be adopted. Like you have to fix the name of the company, you have to decide it. Okay, if it's a industry or it's relating to the industry things, you have to take the license under the Industries Development and Regulation Act 1951. You have to prepare some of the documents, incorporation documents, and needs to file with registrar. We called it ROC, that is Memorandum of Association as well as Article of Association. Now guys, video I will going to bring very soon relating to MOA and DOA. Next is what I'm going to company, whenever at the time of registration they needs to file those type of incorporation documents. What are those incorporation documents? First of all is Memorandum of Association, Article of Association, list of directors, like first director, who are the directors are further appointed by the company in the shareholders meeting, those list. Written consent of the directors, that means you have to obtain the written consent from the directors, that you are not forcing directors to work with you. So they are working with you, they wants to work with you, that they have to declare in a note, and that note you need to submit with ROC, as well as statutory declaration or legal requirements or legal declaration you have to submit. After that, on the registration of all these incorporation documents, that is memorandum, other documents, register is going to issue COI, that is Certificate of Incorporation. And once you receive COI, you can start your business as private company or public company. So this is a procedure of company. So these are the procedure we have discussed for to start or to form the different types of business organization. Hope you like my video. So if you feel you will be benefited from my video, please don't forget to like, share and subscribe. So thank you.